All right. Thank you very much, Kendra. I appreciate it. And yes, I'm very, very excited about the opportunity that we have that we're able to avail to the organic agricultural community here in Florida. Our speaker today is, yeah, we have a long history, so I don't want to get into too much, but I have to give you a little bit of an introduction. He is a stellar representative of the legal profession, but that's just one facet of the many different things that he's done in his life. He has a much, I would say, a very much of an entrepreneurial bent, and he's done many things on the back of his legal expertise. So he has a lot of experience in business, a lot of experience in real estate, and today he's going to lean in a little bit on his real estate background. Let me first start by giving a little bit of his bio, just to give you a sense of who he is. His name is James Mac McCarty. We generally call him Mac. He's a Gainesville based real estate and business attorney and a member of McCarty Fox PLLC. He's a member of the Florida Bar, and he tells me he's coming up on his 40 something anniversary on April 1st, and is board certified by the Florida Bar as a real estate lawyer. He's also certified by the Florida Supreme Court as a circuit civil mediator and as a qualified arbitrator. Mac earned his BA in history, JD, and MBA, and pursued post baccalaureate German studies at Friedrich Wilhelm Universität in Bonn, Germany. Yes, he does speak German. He promised me that he would not make the presentation in German today for the benefit of our community. He has been recognized with membership in several academic honorary societies, including Phi Beta Kappa and Phi Kappa Phi. Throughout his career, he has combined legal practice, business leadership, and higher education teaching. In addition to practicing law across North and Central Florida, he has served in business development and acquisitions roles with WebMD and has held teaching positions at the University of Florida and Jacksonville University. He currently serves as an adjunct instructor in the University of Florida's College of Business Masters of Real Estate program, where he teaches the law of real estate transactions. Mac has been deeply engaged in professional and community leadership, including service as a past president of the 8th Judicial Circuit Bar Association and board roles with organizations such as Alachua Habitat for Humanity and Stop Children's Cancer. We are incredibly honored and pleased to welcome Mr. Mac McCarty. It's all yours.
Thank you, Mark, for that very gracious introduction. I very much appreciate that, and I appreciate the opportunity to speak with this group today and to share what maybe some nuggets that might be considered wisdom now or in the future. But what we're talking about again is legal considerations for organic agricultural use in Florida, and you know before I get started, really, I want to say that this topic and the various rules, laws, other considerations, including common law, that that touch organic farming, it's a huge selection of items. And so, what we can only do today is kind of a high level flyby of these topics, and I'm not sitting here being a proponent for hiring lawyers. But what I will tell you, and well, what I tell my clients is, I don't want you to spend money on me. I want you to be able to save money on my services. And they'll have a quizzical look and they probably don't believe me, but it's true. My idea and my experience has been that a good portion of my work ends up being solving problems that could have been completely avoided had a little bit of money been spent up front. Uh, because these days, having some advice on a formation of a company or how to take title to land or anything like that, those types of items, that's a very small amount of money compared to the huge amount of money that ends up being spent if you end up having to litigate those issues. The cost of litigation these days is absurd. Attorneys' fees rates, even in North Central Florida, which is much lower than South and Central Florida, is still somewhere north of $400 per hour, and it mounts up a lot when you have to litigate a case. So I guess what I'm advocating is the old saying is don't be penny wise and pound foolish, which I unfortunately have to use with my clients sometimes, but to think about, at what points in the process of becoming an organic farmer or owning an organic farming operation, at what points do you really need to think about legal help or other expert help, not just legal, but frequently accounting or consultants that may help you along the way. So be thinking about that as we go through this. But uh, but I'm not really just trying to sell lawyers here. That's not it at all. I'm really just trying to advocate the smart use of some resources early on to avoid having to use a lot of resources later on. So anyway, with that being said, we'll move along here and go through the main topics that we're talking about here. We are in Florida. I have been in Florida since birth, born in Jacksonville. The change that I have seen in Florida is astounding. And the growth of cities, the loss of agricultural areas has been both sad and pretty also astounding for me to see. And so when you're thinking about uh, farming, you need to be thinking about particularly organic farming. You need to be thinking about being in an area and trying to farm in an area that is not going to be quickly overrun with development unless you're trying to uh, buy farmland to later resell for future development. So I'm just saying that in passing because when I grew up, I went to high school in the Treasure Coast area where Indian River citrus was a main product down there during my youth, as well as cattle farming and other types of farming. So what has happened, of course, is population pressures and the change in the importation rules for fruit have not destroyed Indian River fruit, but has made a big change in it. If you look at the farming industry in Lake County up around Claremont and Leesburg, massive changes to that area because in many ways it's become somewhat of a suburb of Orlando. And after a couple of the big freezes, a lot of the agricultural land there, citrus I'm talking about again for the moment, ended up being changed over to housing or just planted pines until housing came in and bought them for prices. So you're in a development climate that is still focused on rapid growth. So when you're thinking about entering this business, you have to keep in mind what kind of pressures and what kind of neighbors you're going to end up having for the farm. This last week, I attended a zoning development committee meeting, or really planning development committee meeting here in Alachua County, Florida. It was a county level meeting, and the county or a city are the ones who, in the main, control zoning that will affect your farmland. Now, you know, typically you're not going to be farming within a city. You're going to be farming within a county. So the county has the right to kind of set the rules as far as what you can and can't do on your property. And the hearing I was at was in one neighborhood opposing the development of a bunch of surrounding land that had been either in part of it was wetlands, part of it was just a green space with some natural growth in there, not old growth because it had been logged sometime in the past, but it was still green space there and wanting to preserve that. So I was representing an association of owners that was there, and there were owners all around on the periphery of this. But the bottom line was because the zoning laws in that area allowed them to build a development, really the development committee really had no choice but to approve at least the preliminary plan to move forward. So when you are thinking about an organic farm, you've got to be thinking in terms of what is the zoning and what is a vested interest versus what is a permissive use or a use that's going to require some form of variance or exception. So making sure I'm clear kind of on that. If you go buy a parcel of land and it is currently zoned for agricultural use, then you have a right to use that land for agricultural purposes. Now, there may be some other rules and regulations that affect what you're going to grow there. For example, if you're going to grow in the marijuana industry, as one example, then the zoning may be for agricultural. Your growth of marijuana might fit in the zoning for agricultural, but there may be a host of other regulations dealing with the marijuana industry that have an impact on that. But back to what I was starting with, which is you would have a right for agricultural use, and but if you wanted to do anything different, anything that went kind of beyond the agricultural use, then you might be into what would be termed either a variance or some manner of exception to the zoning laws. Now, why is that important? Well, it's important because if you have an absolute right, a vested right to do something, then your approval is typically a matter of course with the county zoning officials. If you have to ask for a variance or an exception because you want to do something that falls slightly outside, or if you're trying to reclaim some land, so to speak, that is not currently zoned for agricultural and want to move it back into the agricultural zoning, then you have to go and you have to get approvals. So no committee is obligated, and no commission, like a county commission, is obligated to approve any type of variance or any type of exception. And that's why many times developers who are trying to do something with the land or build something try very hard to stay within the uh, the the items that are a matter of right and are vested to them, such as density and height restrictions on buildings, for just one example. Because once you go outside of that box, that vested box of rights, then you're going to have to get approvals, and that just means that sometimes you win and sometimes you lose, and frequently it is related to what the neighbors may or may not think. Okay, so it's just an idea that the county, if you're in the county as opposed to a city, the county is going to control the zoning on that. And if you're in a city, of course, same thing, but that would be less likely and more unusual for some manner of organic farm. Um, Florida has a number of protections for farmers, which is a great thing. The so-called green belt law that's out there, and you probably will see, I'm certain you'll see in your materials, chapter 193, 461 of the Florida statutes is the part that deals with agricultural exemption. Why is an agricultural exemption important? And I'm talking about an agricultural tax exemption from property taxes. Well, it's because if you are effectively as exempt from taxes, you may have a very small amount for certain items that you still have to pay, but your agricultural exemption makes it economically feasible to own large tracts of land and not face the normal per acre valuation that would be put on that land. Um, I was very blessed some years ago to have a home in 100 acres north of Gainesville, and I sought to get agricultural exemption on the land, and was turned down because they didn't like my tree farm as not being good enough. I probably should have just gone and fenced it better and put goats on it. But the point was that that meant that I was paying full freight on the full value of that land in my property taxes, which is a big number, particularly here in the state of Florida. So the idea is that you find land that you can get the agricultural exemption, and certainly by having an organic farm, and it doesn't have to be an organic farm in that sense, meaning that you can have cattle, you can have goats, you can have horses, you can have other crops, but certainly would apply to an organic farm to be able to receive that agricultural exemption. I get asked frequently whether, say, if we have a farm, let's say we get 20 acres and we want to farm 20 acres of it, and we want to build a house on it. Can we do that? The answer is yes, of course you can build a house on it, and yes, of course you can also get a homestead exemption on that property, assuming the ownership of the parcel is one that allows homestead exemption. You can get a homestead exemption through personal ownership or through ownership by a trust, as long as the trust is set up to reflect that part of the land, or the land will be homestead property as well. But you got to think that through, because even though you might be able to get a homestead exemption on, call it 100 acres again, because it's up to 160 acres outside of the city limits, you only get a $50,000 reduction in your assessed value on your taxes. So you still be paying a boatload of taxes because you're paying full freight on the 160 acres or 100 acres, whatever it is, and you're not going to get the agricultural exemption at the same time over the entire acreage that you're using for farming. So what I've seen people do, and I recommend they do, is they basically carve out their homestead area. Maybe it's an acre, maybe it's 2 acres, and they're going to pay full freight on taxes for those 2 acres, and then they'll be able to claim agricultural exemption, which means basically $0 on the rest of the land that meets the requirements for the agricultural exemption. And each county and the Florida statutes will have the details of what you have to do on the land to receive that exemption. And of course, qualifying for an organic farm would, I can't even think of an example where it would not qualify for an agricultural exemption that would keep your property taxes down to a very minimal level. Okay. And I just already mentioned homestead protection, and the homestead protection against creditors is in the Florida Constitution. And it's a very beneficial protection, because if you ended up getting a judgment against you for whatever reason, the creditor cannot take your homestead. It is protected by the Florida Constitution. But again, there's limitations on that these days. We had a period of time where very wealthy individuals who had big judgments looming would come to Florida, and they would buy multi-million-dollar mansions and dump a lot of money into their homestead so it would be protected against a future judgment. So ultimately, the state of Florida stepped in. The law was changed some to put caps on how much can be protected value-wise in a homestead house like that. So, you got to balance the risk of losing the land versus how much taxes you're going to pay on it as to what gets homesteaded and what is just agricultural. Typically, you're going to be better off, keeping your expenses way down by taking the agricultural exemption on your property. When I talk to groups, sometimes I say to them, I say it is incredibly complicated, because not only do you have Florida statutes to understand that impact what you're trying to do, you also have case law from the courts that may be impacting what you want to do. You may have rules that are in the Florida Administrative Code that will impact what you want to do. And then it's with your area of organic farming, you also have federal laws that impact what you want to do. The so-called Code of Federal Regulations has extremely important requirements regarding organic farming in there. And if you've ever, I started practicing law, by the way, before there were computers. Right at the time computer research was first beginning to come in. But you go to the law library, and the Code of Federal Regulations was volume after volume after volume after volume that was continually changing every time Congress, United States Congress, passed a law, and then that law had to be interpreted and put into some manner of operational regulations, which is what the CFR, the Code of Federal Regulations, is. So, uh, I'm again trying to impress upon you this stuff is not easy. This stuff is complicated. And despite the advent of AI and programs like ChatGPT, uh, it's not going to solve all your issues. I have found from using those types of programs that they can be very helpful um, to kind of point out things that you need to think about, issues, but they're really not good enough at this juncture anyway to rely on to completely draft documents from A to Z. So I use these programs. I also vet the answers to make sure that what I'm seeing really does comport with the actual law. But I don't discount these programs at all, and I think they are very good tools. Now, what I get cranky about is when clients take something I've drafted and then run it through the programs and come back and send me a red line based upon what those programs said. I try to take it in good spirit. Uh, uh, the only one that hurt my feelings was when a program came back and said that my drafting had hit most of the high points despite sloppy drafting. That actually hurt my feelings. So these are good programs, and I encourage their use. What I say is don't rely on them 100% because they are certainly not foolproof at this point, but do provide great information and points to ponder. Um, when you're going in and starting an organic farm, it's not easy in the sense that you have to meet these certifications that are required in the Code of Federal Regulations. And there's some numbers in your outlines to talk about in there. Uh, but the idea is, of course, that you have to be able to get your land certified as organic, uh, pursuant to the requirements of the code. Typically, and I'm not operational as far as organic farms are concerned, meaning I don't get into the nuts and bolts of operations, but you have 36 months of a time period where that land has to be effectively free of any of the chemicals that are outlawed or prohibited, is a better word probably, by the Code of Federal Regulations. And that at the end of that line, it's going to need to be certified by a USDA approved inspector who is going to indicate whether it complies or not. And not only does the land need to be 36 months worth of clean, if you want to look at it that way, you have to make sure also that abutting parcels are not going to have runoff onto your property. So there uh, has to be areas on the borders of abutting parcels to make sure again that your land will not be contaminated during this or any time really, but during this 36-month period in the beginning, to make sure it can be ultimately be certified by one of the third-party USDA approved certification providers, of which there's a great list online that you can go look at. So, you know, so the idea of getting that certification, 36-month time frame, making sure the property is eligible for the tax exemption from the Florida statutes, which almost certainly it would be, although that has to be applied for and renewed by March 1st of every year. And the usage really typically it has to have begun by the tail end of the preceding year with a filing deadline of March the 1st of the year in which you're seeking to have the exemption. Okay. Um, you know, the idea the idea of owning and maintaining an organic farm is that really it's the operator of the farm with which that organic certification is going to run. Now, the land is what's getting certified, but the operator is a key person. And the operator, if it's in the form of a business, which we'll talk about some of those concepts in a minute, but if it's in the form of a business, that business can be passed on. These rights can be assigned and sold over time as long as there's maintenance of the things that have to be done to maintain that certification. I want to move along a little bit here and talk about back to the zoning stuff just a minute. Back probably 20 plus years ago now, the Florida legislature passed rules that required every county and city in the state of Florida to submit a comprehensive plan as to what the current use of property was and to designate future uses of the property looking at their individual counties and cities. Uh, that restriction or that regulation has been modified some over time, but the counties and the cities have future use designations, comprehensive plans that are in place. And it used to be much more difficult than it is now. But the idea was that once the county or city submitted a comprehensive plan, then if the county or city wanted to change that plan, to change the uses of the property, then they would have to go back to the state of Florida for approval, and it was a complicated and expensive process. The idea being, figure out what your plan is, figure out what your future use of your land's going to be, and then try to stick to it as much as you can to try to control unrestricted growth of commercial areas. And you can see this now in current planning where they are trying to preserve agricultural areas. They are very much limiting as much as possible the number of housing units that can be put on agricultural land. Although again, they're trying to prevent the growth of what are called ranchettes, if you want to say it that way, swaths of agricultural land being converted into 5-acre parcels with homes on there because of the loss of agricultural land, but also because it is spreading development way out, leads to problems with infrastructure like roadways and schools. Impact fees are coming from trying to mitigate the cost of those changes that are coming. But also the focus is to try to encourage redevelopment uh, inside certain urban areas to keep as much farmland as possible and to slow down that growth outside of that. So the idea of an organic farm or any farm is that it's going to be encouraged rather than discouraged by the zoning and the future land use map, which is very helpful. They're also the idea of trying to help support farmers by the so-called agritourism, uh, the ability for a farmer not only to raise crops, but also to sell crops and to potentially run seminars and other uh, cash raising services on their particular farms. And saw the advent, of course, over the years of you pick'ems, where people could go and pick their own strawberries or whatever it might be. Those were ways that were deemed to help farmers with the creation of a revenue stream beyond just selling their products to packing houses or other places that would then get them to market. Um, we've talked about we haven't really talked about the Florida Right to Farm Act, which is Florida Statutes Chapter 823 and 0.14 and other places in there. But that's another protection for farmers because if you if you create a farm on a plot of land that is legal when you create it, and it's legal for a year and stays in business for a year after that as you're farming on that, then it is greatly protected from nuisance claims. You've probably all heard of neighboring owners that are complaining about sounds or smells that may come from farms, whether organic or not, quite frankly, and calling them a nuisance. Well, the Right to Farm Act gives a lot of protection against that type of action, protects them from being designated a nuisance. What the statute doesn't do, and what you need to know, is that you still must comply with all the rules and regulations of operation in the county, and of course, any other health codes that might be out there from either the state of Florida or from the county or a city if it was in a city. So you get great protection from the Right to Farm Act, but there are limitations. You can't just do anything on there. You still cannot have unsafe or unhealthy situations or conditions that would be prohibited under the local codes. Okay, so doesn't mean you can change what you do on there if it's against the current zoning or the allocation that you have under the zoning laws on what you can do on the property. But it does protect you from repetitive nuisance lawsuits that are, again, incredibly expensive to defend. It gives you a way to get those dismissed more quickly and more easily. Okay. Um, Talk again about the attorney's role. So when you're buying farmland or if you're leasing farmland, then you have documents. Well, what are those documents? Well, when you buy something, you typically get a deed to the property. When you lease something, you typically have a lease on the property. Both of those are very specific legal documents. A deed, again, is your evidence of ownership. But let's talk about how you take title to property if you're going to actually purchase the property. If you are a single person that is buying the property, then the property can be in your name, or it could be in the name of a limited liability company or a corporation or some other form of business ownership, for example, such as a partnership. So if you buy property in a single name, an individual, okay, you own it. You maybe part of it's homesteaded if you want to build a house on it, and that would be protected from creditors for the homestead portion, and the rest of it would be subject to the potential claims of creditors. If you own it in a corporate name, it gets more complicated. If you own it in a partnership name, it gets more complicated. If you just have three friends who decide to buy the property and it's in the name of three friends, more complicated than you think. In types of ownership of land, if three people buy it together, and they could be called tenants in common, meaning each of the three of them own an undivided 1/3 interest in the property. They could be joint tenants with right of survivorship, which means that if three of them own it and one of them dies, then the other two own the right of the person who died. In other words, it doesn't go to their heirs or to their estate. You can also, again, if an LLC owns the property, then the LLC is controlled by the operating agreement in the LLC. LLCs are companies. They're not corporations, which people tend to say it's a corporate form. It's not a corporate form. It's a company. It's closer really to a partnership than to a corporation in many ways. But it's formed in the state of Florida by filing articles of organization. But it's really the operating agreement that is the guts or the I call it frequently like a premarital or prenuptial agreement, because it sets out the rules of the road for how the LLC operates, whether it's operated by its members, which you can think of as kind of like shareholders, but they're not technically shareholders, and or it can be run by managers who would be elected, or a manager who's elected by the members. But the key here is that obviously you're not going to, there are no homestead rights for an LLC. Homestead rights only run to individuals or trust under certain circumstances. But the LLC can own the land, and it's also a protection to the greater extent from personal liability if something goes wrong and you get sued, because the LLC is a protective form of membership like a corporation where the LLC's assets are at risk, but you don't have personal liability on top of that. If you were to own the property as tenants in common, just three individuals buying it together, then you don't have any You don't have any protection from personal liability, and the land also would still be subject to being taken by some type of judgment. And these are the same issues. Again, with a corporation, think of it as an LLC, but it's a corporation, it has shareholders instead of members, and you get protections in a corporation. But again, the corporation is not going to be exempt from liability for anything that may happen on the land, and the assets of the corporation, just like the assets of the LLC, just like the assets of individuals, would all be at risk if there's a problem. But um, but the individuals in an LLC, the members or the shareholders in a corporation, are going to have protection from personal liability, whereas personal ownership, you have personal liability plus the land would be at risk. So when you think about that, it's a problem because if there's a falling out between the members of an LLC or the shareholders, and by the way, in a small shareholder corporation, it's not an operating agreement like the LLC, but it would be called a shareholders agreement. That would help kind of be the guide path for how the corporation needs to be operated. So if there's a dispute among three owners that own the property as tenants with a right of survivorship or tenants in common, then the real risk there is what's called a partition action, which is another Florida statute uh, governing partition actions. And what a partition action does is one owner can sue the court to either split up the land, like if it's a 120-acre parcel, and it could be split evenly, then it'd be split into three 40-acre parcels, for example. Or more frequently, it's difficult to split the actual land, and the court simply orders a forced sale of the property. Now, you can imagine how badly that would mess up organic farming endeavor, um, because again, if you're in the 36-month period trying to get transition to an organic farm, or afterwards, if you're owning the farm, you have a real risk of losing your certification because of these types of ownership issues. Shifting to the lease concept for a few minutes, the idea of the lease is an interest in land, just like a fee interest from a deed is an interest in land, or in real estate, real property. The lease, same thing. You got three people on the lease. Leases, all three people are liable under the lease. Many times, leases require personal guarantees where you are guaranteeing the payments under the lease to the landlord who would own the property. So the same really is true is that even if it's an LLC or a corporation that leases the property from the landowner, uh, most commercial leases require personal guarantees of some nature signing on. And you have some of, again, the same issues, because if there's a disagreement between the owners, don't want to end up with a problem in the lease or having the lease terminated when you're in your 36-month period or afterwards when you become certified as an organic farm. So in this sense, either a corporation with a shareholders agreement or a limited liability company with an operating agreement are better organizational means, because the operating agreement or the shareholders agreement can determine how someone will exit the organization without destroying the organization. Could happen, can happen anyway. In other words, buy sell provision, where if somebody wants out, they have to sell to the owners, or at least the other owners in there, the shareholders or the other members have the right to purchase the member who wants to get out. So that is that is kind of the idea of being careful as to how you're setting up your operational company and your land ownership or your lease setup. Also, remember, if you're looking to buy land or lease land, really, the idea of due diligence is critical. And this is with any acquisition of property or lease. And these are concepts I teach at the University of Florida as well. Is you need to make sure that you have enough run-up time before you sign a lease or before you purchase a piece of property that you can do proper due diligence. What is due diligence? Well, due diligence is that time period in a proposed lease or the time period in a proposed purchase before you actually sign on the dotted line and make your personal guarantees in the lease, or actually you have to pay the money to own the land, for you to find out everything you can about the property, find out its past uses, find out for your case, what chemicals have been put on the land. Have there been fuel tanks either buried or above ground on the land to service farm equipment that is going to cause a problem because of leakages on the land? What last thing in the world you want to do is to buy or lease an environmental hazard area, because that will be incredibly time consuming and expensive to get cleaned up, and because I've seen test wells and monitoring wells monitoring on property that's gone on for years and years and years. I mean, literally decades on some of these sites, because of the chemicals that got into the groundwater. That obviously would kill any chance of you using the land that you may have bought or may have used or may have leased as an organic farm in the future. Okay. We've already talked a little bit about making sure that the abutting lands aren't running off onto the land that you want to use for an organic farm also. So I can't emphasize enough making sure you do everything possible before you spend money on a lease or buying land before you do so. Uh, I'm really about out of time today. I do want to mention last couple of things. We've already talked about the 36 months before you get to your first harvest of an organic crop up there, and the idea of having to be certified by an approved certifier, a company of which again there are many. But you have to develop, pursuant to the Code of Federal Regulations, Section 205.201, the organic system plan, which is tied to your specific parcel and is really uh, it, it is governed by the Code of Federal Regulations as to being able to describe exactly what you're going to do on the land, how the land's going to be managed, what's going to happen to the land in the future. And these are all things that ultimately have to be approved before you're able to get certified as an organic farm. So I am out of time today, and I apologize for that. And of course, I'll be happy to do some additional, but I don't have time for questions and answers today, for which I apologize if that's okay.
Oh, your apologies are not necessary, Mac. Thank you very, very, very much.
Yeah.
So, you all, I just want to say, Mac, thank you very much. I also want to acknowledge this program has been funded by the support of RAFI, who is a very, very important nonprofit organization out of North Carolina. They're a five-star charity, and they fund a lot of these kind of educational programs and the resources that are going to be developed out of this initiative. So, Mac, thank you very much. I know your time is tight, and we really appreciate it and apologize for the circumstances, but
Yeah, you're welcome. It was unavoidable, and nice meeting you folks, and let me know if I can help you in the future. Thank you.
thank you very much.